recordings are very helpful.
Are these, are they? Okay,
Yeah, reviewing the recordings.
okay, that's great. All right, so before we get into chapter 6, our last chapter before midterm exam, let's just have a very brief review on chapter 5. Chapter 5, we looked at tort law again, but that was unintentional tort, also known as negligence. And is negligence intentional or unintentional? Unintentional, yes, it's a careless conduct. Remember the car accident, it's usually not, most times, not intentional. And there are 4 ingredients that have to be established in court for a negligence tort to be successful. Can you help me with those 4 ingredients? If they are not in order, it's fine.
Duty of care, breach of duty, causation, and damage.
All right. So duty of care, it's, we apply the forcibility test. Is it foreseeable that by acting this way, I may cause an accident or damage? And I told you that this ingredient is rarely challenged in court. So courts have already established that many of those, many of our relationships, there's a duty of care. And if there's a duty of care, the second question is, was the duty breached or not? What is breaching the duty of care? Is it acting within the standard of care? Is it acting below the standard of care? It's acting below the standard of care. Yes. So there's a standard of care. Reasonable person. Not an average, not perfect, but it's a reasonable person. If you act below that standard, you may have breached the duty. What is the example? So if I'm mopping the floor, what is to breach the duty? Sorry?
It's a wet floor sign, not putting it up.
Okay, so I failed to have a sign, slippery floor, caution. Yes, this is an example of breaching my duty of care. So someone just fell down, got injured. The question is, as a defendant, did I owe them a duty of care? Usually the answer is yes. Did I breach the duty, or did I act below the standard of care if the sign was not up? Most likely. And then the 2 other requirements, damage, causation and damage. So damage, if the person was injured, and if the injury was directly related to my wrongful conduct. So this way, we would have, very briefly speaking, we would have a successful negligence tort, right? There were 3 main defenses, and one of the 3 was the most important or the most used for a negligence tort. Can anyone help me? Or what are the 3 defenses available in a negligence tort?
Self-defense.
Self-defense would be available most likely for intentional torts. So if you come to assault me, I self-defend myself, or if you trespass into my property, those examples. Yes. So there's illegality, voluntary assumption of risk, and contributory negligence. So contributory negligence is the one that is used most. What is the key aspect in a contributory negligence tort? What is the defendant saying when they raise this contributory negligence tort defense? What are they saying?
The plaintiff contributed to the loss.
Yes, that the plaintiff contributed to their loss at some extent. So the example I gave you was the,
Or the skateboard.
yes, the ice tubing competition, the competitor that rendered quadriplegic, but the competitor was drunk, visibly drunk. So yes, they were injured, yes, they were compensated, but there was contributory negligence. So I highly recommend you to review this. Also review voluntary assumption of risk. I told you, rarely successful because the victims usually not contribute. They usually assume their physical risks, but not their legal risks. And illegality, courts will still protect someone who was acting illegally in most cases, but you may remember that if you are trespassing or if you break into someone's house, you will not be compensated if you get injured because common law does not protect robbers in those circumstances. So we also looked at occupier's liability. Whoever occupies a property is liable. We looked at product liability. So products that cause injury, loss, or damage, manufacturers may be liable. And you should know situations in which you can sue under product liability as opposed to contract law. So we're going to start looking at contract law today. I did give you some examples on when you would sue under contract, when you would sue under product liability. And we also saw strict liability. Remember, dangerous products, give you the explosive example. Professional liability as well. So when professionals act in a negligent way, could be doctor, could be dentist, could be lawyer, business consultant, accountant, any professionals, any experts. And remember that professionals, they are held to a higher standard of care because they are professionals. So at least in theory, they know more than a regular person, than an average person. And we ended the lecture by looking at insurance, so the types of insurance, and then some concepts within insurance, insurable interest, subrogation, one more. It's just that my mind's now, but okay, it's not going to count, but it's in one of the last slides. So those important concepts you should know on insurance. So that's a very brief review. It's much better when you help me with the concepts. Now we're starting contract law. Contract law is the most important legal topic in this course. We're going to spend 4 chapters on it. So there's this chapter today, and then after the midterm exam, we'll have 3 more chapters. The idea here is not to teach you to review contracts, to be confident to sign contracts. But again, the idea is to share with you law in a legal risk perspective. So where should you be cautious? Aspects of contract law where you should be cautious, you should speak with legal department before engaging into that relationship. Things we're going to look at, first of all, when a contract is valid, because if a contract is not valid, it does not produce any legal facts. And then, even when a contract seems to be valid, there may have been issues forming the contract that may affect the validity of the contract. So we'll see this in chapter 8. And in chapter 9, we'll see when a contract ends, because when it ends, there are no more obligations in most cases. And also we'll see some remedies for breach of contract. So if a party breaches a contract, what are available remedies for the breaching party. So that's what we're gonna see in contract law, but today we're looking at the two first requirements for a valid contract. Well, let's start by defining what a contract is. Simple definition. The simple definition is a contract is this voluntary exchange of promises. If it's voluntary, it's not forced. It's not under threat. It's voluntary. You enter into a contract because you want. Okay? And you are voluntarily exchanging promises. What promise? Well, you purchased the soft drink. So you promise to pay for the soft drink. They promise to give you the soft drink. So there's a voluntary exchange of promises. Again, it's voluntary because if I say no, I'm not willing to sell. No, I don't have products in inventory anymore. I will not commit to that promise. So it's this voluntary exchange of promises that will create obligations. So when the contract is formed, it creates obligations. And if these obligations are defaulted, or any of them are defaulted, the non-breaching party may have them enforced or remedied in court. So going on a very simple example, you purchased coffee. So there was a voluntary exchange of promises to buy coffee. You paid for the coffee. When you got it, it was not coffee, it was tea. So their obligation to give you coffee was defaulted. Or you order coffee, they gave you coffee before paying, so you took the coffee and you ran away. So you defaulted on your obligation to pay for the coffee. So no one would sue for $5, but this is a very simple example where voluntary exchange of promises create obligations, and if any obligation is not met, not performed satisfactorily, there's a breach. Courts may offer remedies. Does it make sense? Simple example, but you can think about employment contract. You can think about consumer contract when you buy a laptop, when you buy anything. Those are contracts, right? There's this freedom of contract concept. In other words, this concept says that parties are free to contract as they wish. So let's say I want to buy your laptop and I want to pay $50 for it. It's unfair, it's very cheap, but if you accept, it's fine. We voluntarily exchanged promises, we created obligations. That's our contract, regardless if it's unfair or not. If you accept, if I have not threatened you, if it was voluntary on your part, voluntary on mine as well, we are free to contract. Does it make sense? This freedom of contract is limited in some circumstances. The best example would be in an employment agreement. In an employment agreement, parties are not as free as they were in a different relationship. Why? Well, let's talk about wage. What is the minimum wage? By the way, it just went into effect June 1st. 1675. So the law says no one can get less than a minimum wage. In other words, parties do not have freedom to contract lower than a minimum wage. So the law in this case, employment law in this case, the Employment Standards Act limits the freedom to contract of the parties. Okay, so how do we understand this freedom to contract concept? Well, we understand it as a general principle in which parties are free to contract in any terms as they wish, unless the law does not prevent them. And the prevention from law. I just gave you an example on the minimum wage. Okay, consumer legislation also offers some limitations on the freedom to contract and other types of transactions. Okay, the duty of good faith. So this duty is a well-established duty in civil law system like Quebec. In common law system, it's quite modern. It's a bit new, last 10 or 20 years. So what does the duty of good faith say? It says that parties, they have to act honestly while performing the obligations they have created, while performing the promises they have voluntarily exchanged that created obligations. So if parties do not act in good faith, they may be sued if they cause damages, if they cause losses for that. So a contract will be valid if it has those 4 ingredients. I'm showing 5 here, but capacity is not a required, let's not take as a required ingredient. The required ones will be consensus, consideration, legality, and intention. So with capacity, we will discuss some aspects that makes a contract to be voidable or void or legal. So today we're going to look at those 2, consensus and consideration. And then after the midterm exam in chapter 7, we're going to look at capacity, legality, and intention. Okay, verbal agreements. They are as binding as written ones. So did you buy coffee? Is it coffee? Did you have an agreement in writing with them or just verbal? Just verbal. Is it less valid as a written agreement? No, it is not. It is as valid as a written one. Okay, and most contracts we enter into, they are verbal actually. If you go to a job interview, after the job interview, they say, hey, can you start working just now? I'm going to pay you minimum wage. You work 4 hours a day. Are you good? Yes, you're good. You start working. You have an agreement. You know your wage, your shift. It's verbal. But what is the negative aspect of a verbal agreement, of an oral agreement? Yeah. You actually don't have written proof. You don't have a permanent record. Because you may have, I would say it's more difficult to prove. Why? Because you may need witnesses. You may need recording. But if it's an employment oral agreement, you may have a copy of your pay stub. That will be proof. It's not proof of the agreement itself, but it's proof of an agreement relationship, right? So the main advantage of a verbal agreement, oral agreement, is the difficulty to obtain proof, to make evidence. It's not impossible, but it's more difficult because there's no permanent record. Is this clear? But they are as valid as written ones. This is very, very important, okay? People usually say, I'm renting this place, but I don't have an agreement. Is this possible? Can you rent something without having an agreement? Technically, you should say, I'm renting this place, but I don't have a written agreement. You have an oral agreement because you have authorization to live there. You know how much you have to pay, when you have to pay. Because if you don't have an agreement to rent, you are actually trespassing, right? So like when we buy coffee, so I bought coffee and if I say, hey, I don't have an agreement. No, I had an agreement, but the agreement was verbal, was oral, because I made an offer, my offer was accepted, and here was the agreement, okay? The receipt is not the agreement, but it's a written evidence. It's a written evidence. because there will be a description of the item, how much you paid, time, address. So it will be evidence, but not the agreement itself. Some concepts we should know with regards to contracts. So express and implied. Express is when it is detailed, when it's expressed actually. So if I want to hire you and I say, hey, I'm going to pay you $20 per hour. $20, this is express. I'm telling you how much I'll pay you. But if I say I'm hiring you and I don't say how much I'll pay you, how much will you make? If you don't negotiate your wage? Nothing?
Whatever the minimum wage.
It's minimum wage. If it's nothing, it's a slavery, right? Not allowed. So yes, we know that no one can work for less than the minimum wage. So if we do not negotiate the wage, it is implied, it is understood that you are getting the minimum wage. So this is implied as opposed to express when I say 20. 20 is express, right? A contract may be valid, void, or voidable. So a valid contract is a contract that has all those requirements. This is a valid contract. A void is a contract that is missing one of these four required elements. And if a contract is valid, it is binding on the parties. It does produce its legal effects. If a contract is void, it's not binding. It does not produce the legal effects. Okay? And a contract can still be voidable. What is a voidable contract? It is a contract that is in principle valid, but may be declared void at the option of the party. We'll go through several examples in chapter 8, but I'll give you just now. So I want to buy your laptop, but I need a laptop that is 2023, and yours is 2021. But you tell me it is 2023, so you lied to me. I buy the laptop from you. In principle, this is a legal contract. I paid you how much you wanted for the laptop. In principle, it is legal. But because you lied to me, the contract becomes voidable. If the victim wants, they may have the contract declared void. And then I may get my money back and I return the laptop to you. But let's say, even after I learned you had lied to me, because the price I paid was a good bargain, I said, oh, okay, I won't bother about being 2021 or 2023. I'm fine with it. In other words, it is voidable, but I, as a victim, I decided not to do anything against it. So as a consequence, the contract is legal. It produces legal effects. Okay, so that's what a voidable contract is. A voidable contract is in principle valid, but at the option of the victim, it may become void. May become. Okay, a contract may be unenforceable or illegal. Unenforceable may be still a legal contract, but courts, they will not enforce. So they are legal contracts. If you buy my apartment, that contract has to be in writing. It's an exception, has to be in writing. But if we enter into a verbal contract, it's a legal contract, but not enforceable. Courts will not enforce if one sues the other. Okay? Whereas an illegal contract is a contract that has an illegal object matter. So what is an illegal subject matter? I may repeat this example next week. So last Saturday, my friends and I had a party. We ordered cocaine through Uber Eats, but cocaine was not of good quality. So my friends wanted to sue the drug dealer. I told them, don't do this because this contract is an illegal contract because there was an illegal subject matter. So we can't sue the drug dealer. Okay? Legally speaking, in real life, we would not want to sue the drug dealer, but legally speaking, we can't. Okay? Because the contract was illegal. Contracts may be bilateral or unilateral. Bilateral is there's this voluntary exchange of promises that create obligations on both parties. So when you order coffee, your obligation is to pay for the coffee. The coffee shop's obligation is to give you the coffee. So it's a bilateral agreement. A unilateral agreement is an agreement in which acceptance is by performance already. So there's no voluntary exchange of promises here. There's a need, there's an offer, and then the other party accepts by performing the agreement. The best example is, let's say there's a post here for a lost puppy. Reward $500 for a lost puppy. So this is an offer. Anyone can accept this offer, but acceptance of this offer is only by finding the puppy. If you find the puppy and return, then you have accepted this offer. So that's why it's a unilateral agreement, because at the beginning, there was no voluntary exchange of promises. There was just an offer for someone who needed their puppy to be found. And there was that other person who actually found their puppy and returned it. Okay, so the contract was formed. What if you find the puppy, you return the puppy, and they don't pay you the reward? What would you do? Yes, you can sue them because there was a contract and they breached the contract. Can you keep the puppy for you? No, you cannot. You would have to sue. So it would be a breach of contract. All right, so those are some important terms. Now, let's look at the first required element. Remember here, we're going to look at those two elements today. First one is consensus. So consensus is this mutual agreement, is this meeting of the minds. What is meeting of the minds? Well, I want to buy something and you want to sell the same thing. So our minds meet. I want to buy coffee. They want to sell coffee. I want to hire you. You want to work for me. So our minds meet. That's consensus. Consensus is parties, they are willing to commit to the terms of the offer. But consensus, as we'll see now, consensus is comprised of an offer. I usually say of a valid offer. The offer has to be valid. And an effective acceptance. Acceptance has to be effective. If it's not effective, it does not create consensus. So now we're going to look at details as to the offer and acceptance, because that's what consensus is. Okay, so starting with an offer. Well, an offer has to be directed to a specific party. So when I ask you, would you like to sell your notebook to me? I am making an offer to you. You will say yes or no. And if you say no, you can also make a counter offer if you want. Okay, or if I just say here, hey, my laptop is for sale. This is not an offer because I'm just saying out loud. An offer has to be directed, has to have the specific terms on it. Okay, an offer may contain a condition, or also known as subject to clause. This is very important. And this is a lot used in real estate transactions. So you are about to buy your first house, 3 million house here in Vancouver. You make an offer. So you go visit the house You want to buy it? Do you buy it without looking at the documents? Without making a due diligence in the property? Do you buy without making a due diligence, or would you make a due diligence before buying? What do you think? You would look at the property? Would you look at the documents? After all, you're investing $3 million, or it could be even $500,000. If it's a one-bedroom apartment, it's still money. So before buying, you make an offer with a condition. The condition is, I'll buy your property if I can secure mortgage. If I go through the due diligence and the due diligence of the documentation is successful. So if that condition is not met, the offer cannot be accepted, or the contract does not start actually. What is a common way? This is also very common in employment agreements, when you get an employment offer. What is the condition we usually see in an employment offer? So you get a job offer, but there's usually a condition in the job offer. Yes. Probationary period. This will not be a condition. This will actually be a time in which the employer will assess whether you are a fit for the company or whether the company is a fit for you. And within this time, they may dismiss you without further compensation. So this does not function actually as a condition. There's something else. So before you actually start working or sign the contract, they want to know something from you. So that's why they make you the offer, but the offer is conditional. Do you agree that Canada has a lot of foreigners? Wouldn't it be possible that some foreigners do not have a work permit? So I can make an offer, a job offer to you, on the condition that you provide me a copy of your work permit if you are a foreigner. So I want to hire you, but you have to provide me a copy of your work permit. If you don't provide, you never meet the condition. So the contract never starts. So a condition has to be fulfilled or waived by the parties so that the contract can start. That's very, very important. Condition or subjective clause. My wife and I, this is real example. My wife and I are trying to buy our first property here in Canada. So when we made a first offer, our first offer had 6 or 7 conditions. First of all, we need to secure mortgage because we are pre-approved, but only after we have a real firm offer, the bank will say, okay, fine, I'll give you this amount of dollars as a mortgage. So first of all, the first condition is upon obtaining mortgage. Second, we're trying to buy a condo, so we want to review the strata documents. We want to review the property documents. We want to have an inspection in the unit. Leaks, installation, functioning of appliances, etc. So those are all conditions. So we are saying to the seller, hey, we want to buy your property, we will pay this amount, but those conditions have to be met. Or we may waive them. We may say, okay, forget about this condition. We don't worry about this anymore. On the other hand, there are aggressive buyers. Sometimes they make offers that are unconditional. They're like purchasing blindly because they're aggressive buyers. They want to buy the property so badly. Anyone can do it. Is it clear? So that's about condition in contracts. Now, invitation to treat. Invitation to treat is an advertisement or when goods are displayed. Why do we need to know about invitation to treat? Because they are not offers. And if they are not offers, they cannot be accepted because only offers can be accepted. So what is an invitation to treat? This is when I say, hey, my laptop is for sale, $500. In other words, I am inviting people to come to me and make an offer. Hey, I want to buy your laptop. Then I will accept the offer or not. When you see, let's say the Porsche dealership, they say, hey, until June 30th, we have an interest rate reduction of 1% for new Porsche leasing or purchase or financing. Is this an offer? This is not an offer. This is an invitation to treat. So if you want to buy that Porsche, and if you want to take advantage of their promotion, then you go there, you go to the dealership and you say, hey, based on your advertisement, I want to buy that Porsche. I want to see your Porsche. When you go to the grocery store, so you get the products. When you get a product, they are displayed on the shelves. They are invitation to treat. They are not offers. If they were offers, if products displayed were offered, when you grab them, you would be accepting the offers. Then you could not change your mind. Because if you changed your mind, you would be breaching a contract. But that's not a contract. It's just an invitation to treat. You get the product, you grab the products, and then when you bring them to the cashier's desk, then you are making an offer to buy them. Okay? So that's important. Offer by conduct. So when do you make an offer by conduct? Yes. Yeah. The taxi is a better example. So when you hail for a taxi driver, you are making them an offer to drive you from that place to somewhere else. And by picking you up, they are accepting your offer by conduct as well. Or do you have a sign written? Hey, this is an offer to drive me from this place to someone else. You don't do this. So offer by conduct. Another example would be the grocery store. Let's think about the self-checkout. You know the self-checkout machines? So when you scan the products, you are making offers by conduct. And by charging you the price, the seller is accepting your offer. So you pay and you leave. You see, you don't speak with the machine. Everything is made by conduct. But there's a contract there. Are we good? All right. So you communicate the offer. Now let's think about an end of an offer. Why is it important to know when an offer ends? Why is it important to know? No longer. Yeah, so after the offer ends, can it be accepted? No, it cannot. So I'm selling my laptop and I say, would you like to buy my laptop for $100? Order is open for the next 10 minutes. If you take 20 minutes to give me an answer, the offer was ended already. Ended offers cannot be accepted. And as an offeror is the one who makes an offer. As an offeror, after my offer ended, I can offer to someone else, right? But if I offer to someone else while my offer is still open to a third party, then I may be in trouble. So an offer will end at specified time if there's one. As I said, you want to buy my laptop, this offer is open for the next 10 minutes. Can also be when the offerer passes away or becomes insane, or when the offerer revokes or withdraws. So would you like to buy my laptop for $100? Before you accept, I say, hey, forget about it. I'm withdrawing my offer. I'm revoking it. But it has to be before acceptance. What if you accept the offer and then I revoke later? That's a breach. It's not revoking. Okay? And revoking, acceptance has to be communicated. Revoking also has to be communicated. The offer will end when it's rejected. If you say, no, thank you, I don't want to buy any laptops. You are rejecting. The offer is ended. When a counter offer is put forward, but what is a counter offer? So I offer you to buy your laptop for 1,000. And you say, no, but I may sell for 1,500. So you made a counter offer. What is a counter offer? A counter offer is first a rejection of the original offer and a new offer. So you rejected my offer for 1,000 and you made an offer for 1,500 now. Is this clear? And then I say, no, thanks. I don't want to pay 1,500. Then you change your mind and say, okay, so if you don't want to pay 1,500, I will accept your 1,000 offer. Can you accept my original 1,000 offer after you made a counter offer? The offer? Exactly. When you made the counter offer, you rejected my original offer. So legally speaking, my original offer was not available anymore. I know in real life, parties would say, yes, okay, fine, let's go ahead. But legally speaking, I wouldn't need to accept or to be willing to accept your acceptance anymore. And why is this important? Let me give you an employment situation. Think about the job, your dream job. Your dream job. You go through a lengthy, complex, very difficult application process. And you finally got the job offer. Job offer of your dream job. One of the benefits is 3 paid week vacation, right? So they are offering you 3 weeks of paid vacation. You want 4 weeks. So you make a counter offer to them. Hey, I'm making a counter offer for 4 weeks vacation, paid vacation, instead of 3 as originally set. They reply to you and say, hey, I'm sorry, but it's against our company's policy, more than 3 weeks paid vacation. Good luck in your job search. And then you start crying right away. You had the dream job offer in your hands and you lost it. Why did you lose it? Because with the counter offer, you rejected it. And then you write to them, no, sorry, I will accept the 3-week paid vacation. And they will reply to you and say, hey, have you missed the B-law lectures at BCAT? When you made the counter offer, you rejected the original offer. So now, bye-bye. I'm being strictly legal. Again, in real life, they wouldn't do this. In real life, they would still accept. In real life, they spent a lot of money, resources to come to you. But legally speaking, they were not required. to hire you after you made a counteroffer and your counteroffer was rejected. So by knowing this, and you still want 4 weeks vacation, what would you do? How would you reply to them? How would you reply this job offer? You know you cannot make a counteroffer, but you still want to check whether 4 weeks vacation is available or not. Sorry?
Reduce something to get something else.
Could be, but see, you have the job offer in your hands and you want to check with them if they can offer you 1 more week of paid vacation without making a counteroffer. Could be, but I don't think you need to go that far initially. All you have to do at least is to avoid putting a counteroffer. So you could just write an email. Say, hey, I was wondering, I would like to check, hey, I just read the job offer, very excited and happy. Just before signing, I was thinking if longer vacation is available, 1 more week of vacation is available. So just checking, you're just wondering. You're not actually making a formal counteroffer, right? And then if they say, no, sorry, 3 weeks paid vacation is maximum as per company's policy. You say, okay, it's fine. So I'm moving ahead, signing. You can send me the signature link. I'll sign this electronically. But again, remember, I'm not here teaching you to be lawyers, but I'm teaching you or trying to teach you how to be smart with regard to the legal aspects of our professional lives. So again, by knowing this, you would avoid making a counteroffer of your dream job, but you would speak with them in different terms. All right, if the subject matter is illegal, the offer is also ended. If the subject matter is destroyed, the offer is also ended. Destroyed. So Diego offered to sell his Porsche to me, and I accepted. But unknown to Diego and I, the Porsche caught fire in the parking lot during the lecture. So the subject matter was destroyed. It means the offer was ended. So if I had made you a transfer or given you a check, you would give me back the check because the offer wouldn't exist. Okay, that's an example here. Offers with regards to option agreement. Well, what is an option agreement? Option agreement is when you buy time. You are not buying the property, you are buying time. So real estate transaction again. You go see a house, you like the house, you are thinking about making an offer to buy that house, but before you make an offer, you want your partner to see the house, you want your children to see the house, but you don't want the seller to sell the house to anyone else. So you enter into an option agreement. You pay some money for some time. So within this time, the house cannot be sold to anyone else. But the option agreement does not oblige you to buy the house. The option agreement gives you time to move ahead purchasing the house or not. You're just guaranteeing the object matter of the contract is there available to you. Does it make sense? That's an option agreement. All right, question for you. And there may be a similar question in your exam.
Letter A.
Okay, so you're saying that this best offer in Toronto is actually an invitation to treat, not a legal offer. Right? Do you agree? Yeah, letter A is right. Because it's not directed to anyone, it's just an ad, it's an advertisement. If you are interested in this 3-bedroom home, then you go there and you make an offer. Hey, I want to buy this house. And then they will accept or not. Clear? So even though they have used the word offer, the offer here is meant as promotion, as advertisement. Invitation to treat, not legal offer. Very good. All right, what is a standard form contract? This is a contract that cannot be negotiated. The clauses are not negotiated. Who has a banking account here? Checking or savings account? Who has? Okay, when you started your banking account, did you negotiate the agreement with the bank or you just signed? Just signed. The bank manager just printed all documents and you just signed. So it means that those are standard form contracts. The terms, they are fixed. They won't be changed. Why is this important? Well, this is important because if there are ambiguities in that contract, courts will interpret those ambiguities in our favor, in favor of the client. We still have to read the contracts, but even if we read and accept, we can still be able to challenge those contracts or specific clauses in court because they are usually one-sided terms. They are usually favorable to the party who wrote the contract, the bank in this example. Airline tickets, the same thing. When you purchase your last airline ticket, did you call the airline and said, hey, section number 20, I disagree. Can you please change so that I can issue my ticket? Did you do this? No, we don't do this. We just purchased the ticket. So this is another example of a standard form contract. Okay. Now let's look at acceptance. And by the way, just to remind you, we are still talking about the first one. We're still talking about consensus. We're still talking about valid offer. We just finished valid offer. Now we're going to look at what an effective acceptance is, because it will form consensus. So acceptance is the offeree's intention to commit. May I have coffee? I come to Tim Hortons and say, may I have coffee, please? May I have a small coffee? So I am voluntarily exchanging a promise. If they accept, they say yes. And then they tell me the price. So promises, voluntary exchange of promises are now forming a contract. It is now creating an obligation. That's what acceptance is. The acceptance has to be unconditional. You cannot change the conditions of the offer. If you change the conditions of the offer when you accept an offer, what are you doing? A counteroffer. And a counteroffer, we just learned that it is the rejection of the original offer and the make of a new offer. So acceptance has to be unconditional. What else? Acceptance has to be communicated to the offerer. So communication can be by conduct or can be expressed, but it has to be communicated. Silence is not acceptance. If you ask me, hey, João, would you like to buy my smartphone? $1,000? If I'm silent, I'm not accepting. I need to communicate to you, yes, I want to buy it. Silence may be acceptance in an ongoing business relationship. So now I have a coffee shop and there's this supplier of coffee. They bring coffee every week to me or every month. They increase the price of coffee, and I don't accept formally, but I keep on receiving the products, preparing coffee, selling. So this silence, but accepting the benefit means acceptance. What else is important here? Postbox rule, not so common nowadays. So postbox rule is when acceptance is by mail. So instead of calling, sending an email accepting, you mail your acceptance. And what the postbox rule says is, at the time you mail, you have accepted. Acceptance is effective. Think about this company based in Ontario. They made an offer to me, and my acceptance must be by mail, right? So just before lecture today, I mailed them my acceptance. And 5 minutes ago, they called me and said, hey, that offer is ended. We are revoking it. Is this revocation effective?
Yeah.
Why not?
Everybody send the acceptance to the mail.
I have already posted my acceptance. And based on the postbox rule, when I mailed my acceptance, contract was formed right away. So if they decide to change their minds, they are actually breaching the contract. What is the legal importance for this? For you, as business people, do not accept acceptances by mail. Because if you do this, it may be that your offer has already been accepted and you don't know yet. My letter will get, my acceptance letter or mail will only get in Toronto. I don't know, 5 days from now, 10 days from now. So as an offerer, avoid using acceptances by mail. Okay? So that's how it is. Okay, with regards to electronic transactions, it's just saying that electronic contracts, they are valid in Canada. Legislation recognizes electronic contracts. When we click on I accept the terms and conditions, we are accepting a contract. We are forming a contract. There's also legislation in Canada that accepts electronic signatures. So they are all valid. All right, so that's consensus. We just finished consensus. Consensus as the first required element of a contract. What is consensus? The meeting of the minds. When does this happen? When there's a valid offer, effective acceptance. So I spoke a lot, but what I meant was this: valid offer, effective acceptance. When they are there, consensus is formed. A contract is formed. Are we good? All right. Let's break, and then we'll come through the second required element.
How long is break?
All right. So let's resume. Second required element for a contract to be valid is known as consideration. What is consideration? It is the mutual benefit. So all contracting parties, they need to derive a benefit from a contract. When you buy coffee, what is your benefit? Coffee. What is the benefit of the coffee shop? Money. So in other words, what I'm saying to you is that gifts, contracts in which, or agreements in which there's a gratuitous promise, there's a free promise, they are not enforceable contracts. So if you get a coffee for free, you still have the coffee as a benefit, but the coffee shop, they don't have a direct benefit from the coffee. You may say they have a benefit with regards to marketing or anything else, but not a direct benefit in that transaction. So all contracts, they need to offer mutual benefit to both parties. We can also say that consideration is the price each party is paying. When you buy coffee, what is your price? Don't overthink. Yeah, the money you pay. What is the price for the coffee shop? The coffee. It leaves their inventory and they have purchased it. So its consideration is understood as either the mutual benefit or the mutual price to be paid. Okay? Why is this important? Well, it's important because if there's no consideration, the contract is not enforceable. The contract will not be valid. And then let's think about this when we want to change a contract. When you want to change a contract, you have to offer new consideration. You have to offer a new benefit. Parties need to derive new mutual benefit. So let's think about employment agreement. When you get the job offer and you accept the job offer, what are your benefits? What is your consideration, the benefits of the employee? What are you getting from that job? Payment, wages, benefits in general, safe workplace. Okay, so those are your benefits. In other words, these are the price that the employer will pay to you. Are we clear? What price are you paying to the employer? Or what is the benefit of the employer?
Services provided by
The services provided, the experience, the knowledge, loyalty. Are we clear? Okay. Now the employer wants to change your agreement. They want to change your wage from 20 to 25. Are you getting a new benefit?
Yes.
Yes, you are. $5 more. Are they getting any benefit? Potentially. What benefit are they getting? What direct benefit are they getting by providing you, by giving you a raise in your wage?
You will stay.
But the fact, it's a valid point, you will stay, but the fact that you are there is a consideration that you have exchanged when you accepted the job offer. Now you need to offer a new benefit to the employer. More job duties. But if I'm getting a raise, I'm not offering more job duties, but I may offer one more task to be responsible for, then there will be a valid consideration, a fresh consideration. If I don't offer anything in exchange for a raise, it is actually a gratuitous promise. And if the employer does not give you the raise after they have promised, months after, you cannot sue them because it's not going to be enforceable in court. What is the message here? Can contracts be changed? Yes, they can. As long as both parties derive a benefit from that change. As long as both parties pay a new price for that change. Does it make sense? Do you have a question? No? And this consideration needs to have a material value, but doesn't need to be fair. In legal, the legal environment or legal world, sometimes you see contracts that read like this. In consideration of $1, parties agree as follows. And then there are sections to change the agreement. So in consideration of $1, it may be unfair, but it's a stated value. So it meets the consideration requirement. Okay? So consideration is this mutual benefit, this mutual price. Both parties need to derive a benefit. There's exceptions to valid consideration as promissory estoppel, but you can skip this. I won't enter into this detailed aspect. Okay, you can skip this. You may read still if you want to know more about this. You can even ask me questions if you want to, but this will not be in your exam. So practice this consideration, fresh consideration in this question. A, nothing. When you say nothing, you mean there's no valid consideration and there's no fresh consideration. So both the contract and the change to the contract, both of them are not valid. And I'm not saying this is right or wrong. I'm just saying when you conclude it's nothing. Was that B? B, Bob, 500. When you say 500, you say that the original contract is legal, but the change in the contract is not legal because it misses a fresh consideration. C, with C, you're saying both considerations are valid.
He stated that because X agreed that he will pay if he moves out.
Okay. That's an important aspect here.
If you pay me-
X agreed.
Yeah.
Okay, but it's not only about agreeing, because as an employer, I can come to you and I say, hey, I'm gonna give you $5 increase, and you agree. But if you don't give me anything in return, even though there's agreement, there's no fresh consideration. I'm not saying you're wrong, I'm just saying that the agreed part is not the key part, right? We're still checking whether there's valid consideration or not, whether there's valid mutual benefit or not. Let's do this together. And you may be right. Let's do it together. So, payment 500, and the terms of the cabinet, they are quality of the wood, dimensions, and date of completion. So, as a supplier, how much am I getting? 500. And as a buyer, what am I getting? I'm getting a cabinet under those terms. Type and quality of the wood, Dimensions and completion date of February 13. That's the original agreement. Is this a valid agreement or not? Yes, it is. There's consensus, there's consideration. So, yes, 500 has to be paid. But let's continue. The work went more easily. So Z offered, if you pay me extra, in other words, if you give me more benefit, I can give you more benefit as well. So if you give me more money, I can change the terms and deliver the cabinet 3 days earlier. Is this a benefit?
Yeah.
Yes, it is. So there's also mutual benefit in the change of the contract. So yes, 585. Because there's valid consideration in both parts, the original contract and the change of the contract. Yes.
What would be considered a quote unquote fair price?
Courts would rarely come to a fair price. But a fair price would be a comparable price. So how much would a comparable type and quality of wood cabinet be? But courts would say this contract is void. They wouldn't force a fair price to be paid. They would either apply the parties' agreement, real intentions, or declare the contract as void. Okay. Is this clear? So if a gardener comes to my house and they say, hey, front and backyards, $500. And I say, fine. And then it's going easier. And they come to me and say, hey, I can change, I can finish faster if you pay me $100 more. Did we agree about the time initially? We didn't. Finishing faster now, is this a benefit for me? No, it is not, because we didn't negotiate time. So in this case, I could say, yes, please go ahead. Even though I had agreed, there's no valid consideration for the extra $100. So when they finish faster and they come and charge me the $600, I'll say, no, I'll pay 500. Because the extra 100 lacks valid consideration, hence it is unenforceable. Clear? But if they had said, hey, I can, if you pay me $100 more, I can also trim your the branches of your trees. Do I get a new benefit? Yes. Now branches will be trimmed. Then I will pay $100 more. Then there's valid consideration. Is this clear? What is the lesson here? The lesson is if you get if you are promised a raise, you either give something back, or if you are religious, start praying so that you get the raise. Because if you don't get, you cannot sue the company, right? Okay, so that's consideration, the second required element. Questions here?